Welcome to this explainer. When you think of Apple, you're probably picturing sleek iPhones, innovative MacBooks, maybe those iconic marketing campaigns. But behind all that polished glass and aluminum sits a fascinating, incredibly complex, and, quite frankly, aggressive legal machine. Today, we're going to unpack exactly how Apple has utilized the legal system from its earliest startup days right up to the present.
Now, for most companies out there, litigation is just an expensive headache, right? A cost of doing business. But as we comb through the history, a very different picture emerges. Apple doesn't just settle disputes to make them go away. They use the law as a core asset, both offensively and defensively, to maintain their market dominance. It's like they treat their intellectual property exactly like physical real estate, and they are definitely not afraid to fight for every single square inch of it.
To really get a handle on this, we're going to map out Apple's litigation web in 5 parts. First, the litigation strategy. Second, defending the brand. Third, copyrights and code. Fourth, consumer class actions. And finally, the antitrust era.
All right, kicking things off with part 1, the litigation strategy and how they enforce the Apple ecosystem.
As a member of the Business Software Alliance, Apple is notoriously aggressive about policing its IP. Whether we're talking patents, trademarks, or copyrights, the courts are just one of the tools they use to swat away anyone encroaching on their territory. I mean, Steve Jobs alone was a named inventor on over 300 patents. Just to give you an idea of the sheer scale here, between January 2008 and May 2010 alone, Apple filed over 350 cases with the U.S. Patent and Trademark Office. 350! They were going after anyone using terms like Apple, Pod, or Safari. And get this, it wasn't just tech companies. They literally went after sellers of actual physical apples who used the name in ways Apple felt crossed the line.
Moving right along to part 2, defending the brand. We're talking trademarks, name-calling, and the Beatles.
See, defending a brand isn't just about stopping counterfeiters. It's about controlling the cultural real estate of a name. Take Apple's literal 30-year legal tug-of-war with the Beatles holding company Apple Corps. This whole thing started way back in 1978. Apple Computer initially settled for $80 grand, promising they'd stay out of the music business entirely. But, as technology evolved, Apple kinda kept creeping into audio. In 1991, they added a synthesizer chip to a Mac, which resulted in a $26.5 million settlement. Then, of course, came the iPod and iTunes in 2003, prompting another massive lawsuit. This multi-decade saga only finally wrapped up in 2007 when Apple Inc. essentially bought the trademark rights and licensed them back to the music label. Wild, right?
And honestly, this next story perfectly captures the quirky, kind of petty side of early Apple culture. Back in 1994, Apple engineers used the internal codename Carl Sagan for a new computer, hoping it would make billions and billions. Well, Sagan didn't want to endorse the product, so he sent a cease and desist letter. Apple complied, but the engineers actually retaliated by changing the codename to BHA, which stood for Butthead Astronomer. Seriously? Sagan actually sued them for libel over this. The judge ended up dismissing it, noting that Butthead isn't exactly a serious scientific critique. So what did Apple do? They changed the codename one last time to Law, short for Lawyers Are Wimps. But jokes aside, they have been absolutely relentless in targeting anyone getting too close to their visual identity or naming conventions. They actually opposed New York City's Green YC environmental logo because it featured a stylized apple. They went after Woolworths in Australia for a Wii logo that just looked vaguely Apple-like. They even sent a cease and desist to a small business school in Canada for having an apple in their logo. And most famously, they had a major dispute with Cisco, who actually owned the iPhone trademark for a VoIP device before Apple even launched their iconic cell phone. They eventually reached an agreement, but it just shows you that Apple really leaves no stone unturned. Which brings us to part 3, copyrights and code, and how Apple helps define software law. This whole strategy wasn't just about branding. It bled into the very fabric of the digital world. Apple didn't just play by the rules of software law. Their litigation actually helped shape its foundation. Back in the 1980s, the concept of software copyright was entirely new. Like, if a programmer writes code in English like syntax source code, that's a written work. Makes sense. But what about object code, the literal ones and zeros etched into a silicon chip? Apple's fight to protect this resulted in a massive international conflict of laws. An Australian court ruled that object code was not copyrightable. Meanwhile, the Canadian Supreme Court ruled that it was, comparing it to a translation of a literary work. It was a messy, totally uncharted legal frontier.
So the crucial takeaway here is that cases like Apple v. Franklin in the US actually laid the groundwork for how the law treats the code powering the devices we use today. The courts ultimately decided that yes, even firmware, object code embedded in hardware, can be copyrighted, Without these early, super aggressive litigations by Apple to protect the Apple II operating system, the entire modern software industry would literally lack the legal protections it completely relies on today.
Now, let's flip the script for Part 4, consumer class actions, and look at Apple on the defensive.
Because the courtroom isn't always a place where Apple gets to play offense. The narrative shifts drastically when we look at them facing off against their own massive user base in consumer class action lawsuits. Over the years, everyday consumers have banded together to target hardware flaws and software mechanics. In the 2000s, it was those early iPod batteries that just couldn't hold a charge over time. In the 2010s, they had to settle over older MagSafe power adapters that kept fraying. And then there was the huge issue of kids racking up thousands of dollars in hidden in-app purchases on games that were supposedly free.
And these consumer actions, they lead to massive payouts. We're talking a staggering $500 million settlement in 2020. This happened after they confirmed they had intentionally adjusted operating systems to slow down older iPhones. Now, Apple stated this was strictly to manage degrading lithium-ion batteries and prevent unexpected shutdowns. But consumers sued, arguing they were essentially forced to buy new phones or replacement batteries because of this unannounced throttling.
Or how about this $100 million settlement? This was the result of a class action suit plus an FTC investigation driven by parents who were absolutely furious over those undisclosed in-app purchases made by their children. Apple had to compensate customers who found themselves hit with massive credit card bills simply because their kids were tapping away on an iPad screen. It's a solid reminder that even the biggest tech giants in the world are ultimately accountable to the consumers who buy their products.
Finally, we arrive at Part 5, the antitrust era, facing global governments.
This is really the climax of Apple's legal journey. They're no longer just fighting individuals, quirky astronomers, or even rival tech companies. They are facing off against global governments and giant corporate rivals who argue that Apple's ecosystem has just become too powerful. To really grasp the stakes here, we have to look at what antitrust actually means. These are laws and regulations designed to promote fair competition and prevent monopolies. When a company controls the hardware, the software, and the marketplace, like Apple does with the iPhone and the App Store, regulators start asking some tough questions about whether they're unfairly locking out the competition.
And this level of control has led to some intense global scrutiny. In 2012, the U.S. Justice Department successfully sued Apple, citing compelling evidence that they conspired with publishers to fix the prices of ebooks just to fight off Amazon. Fast forward to March 2024, the European Union handed down a staggering €1.8 billion fine after Spotify complained about Apple abusing its dominant market position in music streaming. And get this, that exact same month, the US DOJ filed a massive anti-monopoly lawsuit claiming Apple suppresses competition in digital wallets, messaging apps, and smartwatches.
Perhaps nothing highlights this struggle better than the 2020 Epic Games lawsuit. The creators of Fortnite actually sued Apple over that mandatory 30% revenue cut in the App Store. While the judge cleared Apple on several antitrust counts, they did find that Apple's anti-steering provision violated California law. This resulted in a permanent injunction, meaning Apple can no longer block developers from linking to third-party payment systems outside the App Store. The walls of that famously walled garden are being tested in court like never before.
Which leaves us with this final, absolutely vital thought to take away. When we look at this history, from copywriting the very first lines of code to battling governments over billion-dollar app economies, we have to ask ourselves, how do the legal battles of a single tech giant shape the boundaries of our digital world? Because when a company gets this big, their courtroom strategies don't just protect their bottom line, they literally write the rules for the technology we live by every single day. Thanks for joining me on this explainer. Keep questioning the tech in your pocket, and I'll catch you next time.